Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're talking about domestic abuse and child custody. This episode includes details of a case that may be distressing for some viewers. On February 9th, 2020, Robin Brown took his 4-year-old daughter, Kira, hiking at Rattlesnake Point in Milton, Ontario. Later that day, police found their bodies at the bottom of a cliff. Police suspect it was a murder-suicide. Brown was a well-known domestic abuser who had a pattern established of physical and emotional abuse directed at his ex-wife, Jennifer Kagan. In spite of this, a family court judge granted Brown overnight visits with Kira and a 40-60 residential split. Brown's behavior continued to escalate as he used custody as a way of continuing to control his ex-wife. Jennifer filed an urgent motion asking for Brown's access to Kira to be suspended. But despite his escalating behavior and erratic behavior, the judge found that the matter was not urgent. 12 days later, Brown killed Kira and himself. Here today is Kira's mother, Jennifer Kagan, and her husband, Philip Viater, to discuss their case and the work they're doing advocating for changes to the family law system to prevent future cases like this. Jennifer, I'm so sorry. Your story is a nightmare, and I really can't imagine what this has been like for you. So thank you for your courage coming on today and to your fight for other children who might be in a similar situation. To start, I wanted to know if you could just tell us a little bit about Kira and what she was like.
Yes, and thank you for having us. So Kira was my daughter and Philip's stepdaughter, and she was a bright light. She was a sweet, innocent, spunky little 4-year-old who would have had a very bright future ahead of her had she not been horrendously failed by the family court system and Jewish Family Child Services.
So one of the things that stood out to me in your case, Jennifer, was that the judge found that the history of abuse was not relevant to custody of your daughter that your ex-husband received. Is that common? Because I think it would be the public would be surprised to hear that the level of abuse that you dealt with was not determined to be relevant by a judge.
And it's an erroneous notion that domestic abuse is not relevant to parenting, and that type of, it's so incorrect. And that really highlights the need for judges to be educated on domestic violence and coercive control. A history of violence towards the partner, coercive controlling behavior. When you have somebody who's a very dangerous perpetrator, this is all extremely relevant to parenting, right? You can't separate the two, because what the perpetrator will do is use the child to then get his claws into the victim. So the child is a victim as well. And children also, they're not just exposed to domestic violence, they experience it. So we really need to, judges really need to have that education on domestic violence and coercive control when making decisions about the best interests of children.
Now, Philip, I wanted to ask about the days that were leading up to the murder. Why did you Jennifer bring the urgent motion to have her ex-husband's custody revoked? What was happening that led you to bring that motion?
So it's a little more complicated than the last few days, because leading the probably 6 months leading up to the murder, there were a series of judicial findings made against Mr. Brown, such as him trying to commit a fraud on the court, where he served us with one document and then pretended filed something completely different in the court. His access was actually curtailed a little bit in one ruling in August, with strong warnings that his access could be curtailed further. Then he kidnapped Kira. A judge ordered her immediate return and actually suspended his access for a whole week, and then reinstated it, again with strong warnings, and then more orders with him not complying with court orders, and just didn't matter what the judges were saying. And he was escalating to such an alarming level and crossing lines that were just horrible. So we believe that Kira was in danger. Her psychologist also believed that she was in danger. And so we brought that emergency motion to have his access either suspended or at least supervised for the time being.
Philip, we've only got 30 seconds left, but I wanted you to respond to that previous question I had about, is it common for judges to think it's not relevant that there was domestic abuse against a spouse in a custody decision?
It's a roulette wheel. You may have a judge who is more abuse informed and will consider it relevant. then you have many judges who are not abuse informed, don't have the training, and they will perhaps ignore it. And so it is actually quite common. And that's the horrible thing. A child's life will depend on which judge you get.
We've got to go to commercial break, but we will be right back. Welcome back to Canadian Justice, where we're discussing how the family court system failed 4-year-old Kira, who was murdered by her abusive father. We're talking to Jennifer and Philip, Kira's mother and stepfather. Now, Jennifer, the court labeled, the judge labeled your divorce as high conflict, but there's obviously a difference between a toxic or high conflict divorce and a divorce where one party has a long and established pattern of abuse. So what can you tell me about that difference, and how well do you think that difference is understood by judges and even by the public?
Well, the first thing I'll say is that the term high conflict does an immense disservice to domestic violence victims, and it's an extremely dangerous term, right? The term high conflict would denote that both parties are involved in perpetuating the conflict, whereas a domestic violence case is distinctly different. You have a clear pattern of behavior with one perpetrator perpetuating the conflict, trying to get his claws into the other, who's the victim, who may be trying to protect the child from the harm given the perpetrator's behavior. So the two must be distinguished from one another. And when this doesn't happen in the courts, we lump, these bitter splits in with the truly dangerous ones. And the end result is that children like my daughter are killed.
Philip, same question to you. How do we distinguish between high conflict and domestic abuse? And do you think there's been a misunderstanding in the courts?
There has been a huge misunderstanding, which is why the education is so important. Because when you label something high conflict instead of abuse, a few things happen. First of all, the perpetrators love it because there's now no accountability for their actions, so they just continue it. And the court, in some regards, becomes an unwitting enabler for that to continue. And then the other problem is that if you're looking at the case through the wrong lens, then the orders and directions that a judge is going to give and make are completely wrong. You're going to give a completely different set of directions to somebody who's abused than two people who simply don't get along. And then if you're looking at it through the wrong lens again, then you may fail to understand trauma responses of an abuse victim, where they could come off as overly protective. But if you don't understand that they're legitimately being protective because they are victims of abuse, then you may make the wrong orders, and it happens all the time, and it's wrong.
Jennifer, one of the things that stands out to me so starkly about your case is that Philip, your husband, is a family lawyer. So of anyone, I would think, navigating the system, it was such a clear-cut case. In your case, you have this kind of in-house edge, and the system still failed you. So what hope is there in the current system for, regular abuse victims who don't have, their own family lawyer who they're married to, who don't have the resources to fight tooth and nail for their children?
I mean, my case really highlights the abject failures of the family court system for victims of violence and for children. I mean, fortunately, we did have the resources. And as you say, my husband understood the system, and yet still Kira was failed. In many, many cases, there are further barriers to access to justice. And, in my case, for example, when you have the perpetrator abduct, our daughter, I'm able to afford to pay for a lawyer to have her returned to my care. But you can only imagine the suffering of children when, the resources are more of an issue, and it's hugely unfair. And so, if we still couldn't protect Kira in this situation, one can only imagine all of the other failures for children in many other cases. And it's very wrong.
Philip, if there's anything you want to add to that.
Yeah, I think, the more we relay the story to the public, and everyone is just so shocked about this obvious failure. We weren't silent in the court. It's not like we stood there and, with our heads buried in the sand. We relayed this information to the court, to Jewish Family and Child Services, and it was ignored or minimized or whatever. And I think the highlight that I would, stress is our case was so extreme And it still failed. And just as kind of Jennifer's point, if it's failing us, imagine what it's doing to cases who are less extreme, but still serious just the same. Maybe the abuse won't end up in murder, but there's still abuse going on and it's clearly being ignored.
And of course, there was a alleged failure here. You're alleging a failure by Jewish Children Family Services as well. And in the next episode, we're going to be discussing your lawsuit against them for the failures that they had in their investigation and their failures that they had to protect your daughter, Kira. We've got to go to commercial break, but when we come back, I want to talk in detail about your proposed changes to the law to better protect other children. Welcome back to Canadian Justice, where we're discussing how the family law system failed a 4-year-old girl named Kira, who was murdered by her abusive father. Jennifer, you have been working to change the system so that this never happens to another child ever again. What can you tell me about the proposed change to the law that you're advocating for? It's called Kira's Law.
Yes, so Kira's Law is contained in Bill C-233 that was recently tabled in the Canadian House of Commons. And Kira's Law will provide for continuing education seminars for judges in the area of domestic violence and coercive control. So it will equip judges with the tools they need to understand domestic violence, coercive controlling behavior, risks to children, and to ensure that child safety is at the forefront.
And do you think that if a law like that had been in place, if there was better training for judges, that could have prevented Kira's death?
I think it would have made considerable difference for Kira had the judges been educated in domestic violence and coercive controlling behavior.
Philip, is there anything you want to add to what Kira's Law is proposing?
Well, I think it's a really important step because judges are the ultimate gatekeeper for children. When people come to court, they expect that a judge will have knowledge and training in areas of domestic violence, of coercive control, so that when you go out, you have a free forum to go and explain what's going on and have somebody who will listen and understand. That's not what's occurring right now. And right now, the public has very little confidence in the judicial system. We need to rebuild that confidence, but more importantly, we want to ensure the protection and safety of children and victims of violence.
Now, Philip, there was also another change in the law, I think last year, an amendment to the Divorce Act that requires judges to take into account domestic violence when rendering custody decisions. What can you tell me about that law? Did that law do enough to change things for children? Would a law like that have protected Kira?
No, what I always say is the law is well written and it's very nice to hear, but they're just words on a piece of paper. I could tell you as a family law lawyer myself, any skilled lawyer has been arguing domestic violence when it was an issue. We've been arguing it for years or since, the beginning of time. Judges have already been taking that into account. And in fact, there are so many decisions that have come out where judges have even indicated that all the law has done is just codify what was already pre-existing in a best interest of the child test. So it's nice on a piece of paper. The missing piece to that puzzle, the disconnect, is that you've provided this law, which is great for the public, but you haven't given the judges the tools to implement the law. That's the missing piece. You say, consider family violence. Well, guess what? That's one of numerous factors that a court considers. And it's even in the law, one of numerous factors. So give them the tools that they need to understand how important a factor that actually is. That's what's missing.
So Jennifer, Kira's Law is proposing training for judges. What would that training look like?
It would basically to educate the judges on, what these patterns of behavior look like. And coercive control is a pattern of behavior. It's harm towards predominantly women and children. And so, it would, it would really help the judges to understand what, not only the theory, but also what these patterns of behavior look like in real life. What are risk factors for lethality? When is a child at risk? What are signs and symptoms that you might see in the child that would bespeak an issue, with domestic violence, child abuse, mental health, sort of all of this kind of behavioral science type of training is really what's needed.
And Philip, are there other cases where you think this training would make a difference? How common are things like this? How common is it for a parent to murder their own child this way? And do you think that the pandemic has made things worse?
So I know Jennifer knows the statistic a little bit better, but if I'm not mistaken, 30 children are killed a year by a parent. Women are killed in even greater numbers by a former abusive spouse. So, this is a prevalent issue, and the pandemic, I think, has exacerbated the issue more. People are stuck with their abusers, at least, in the past, because look, there's a lot of social science literature that, some abusers or some abused people stay with their abuser for a variety of reasons, whether they're scared, whatever the reasons were. So now they're forced to be confined with their abusers. They don't even have that break to go to work, for example, in some cases, and get away. And they're isolated from family and friends.
We've got to go to commercial, but we'll be right back. Welcome back to Canadian Justice, where we're discussing how the family law system failed a 4-year-old girl named Kira, who was murdered by her abusive father. Now, Kira's father had custody of her. Mr. Brown had custody of her that weekend. And Jennifer, you've talked about how there appears to be a bias in the courts in favor of contact at all costs. And it seems like that was at play here. What more can you tell us about that bias?
There definitely is a bias, a pro-contact culture, and really a systemic minimization of abuse that, many women have reported to me they're fearful to even disclose abuse in the courts. They've been advised by their lawyer not to disclose. There's this, this use of this allegation of alienation by the perpetrator, which, basically obfuscates from any concerns about abuse. It sort of shuts that down, and women can actually risk losing custody when that allegation is leveled. So it's hugely problematic. And, in general, I would not advise any survivor of violence to go into the family court system, knowing about these biases. However, victims of violence don't have a choice. They don't want to be there. They're trying to protect the child. Many times they're not. As in my case, I was not the one to bring a court application. I was simply responding. So there's really no choice. You can't mediate with an abuser, right? You can't negotiate with a terrorist. So when you're escaping a dangerous individual, survivor may not have any choice but to rely on the family court and child protection systems.
So, Philip, is there anything you can add about that bias in the courts that provides for contact, even in extreme cases like this one?
Yeah, it definitely exists, and I think the problem is that the judges always operate under the assumption that these are two loving parents who just don't get along, and they refuse, for whatever reason, or they're very resistant to wanting to believe that a parent is using a child to harm the other parent. They think that everyone could just get along, and they won't acknowledge that some people are unable to do it. And you can't treat every case the same way. Yes, there are cases where it's two parents who legitimately don't get along. But if one parent is saying that, look, this guy is extremely abusive, for example, all right, and I'm fearful for the safety of my child, you can't just lump them in with every other parent who squabbles. You have to investigate it. You have to take it seriously. And right now, they're not doing it. They tell everyone, get along, and they don't understand that for the perpetrator, they're intentionally not getting along. The whole point is to not get along. And they love it when judges are neutral because they just continue to do it, to abuse in perpetuity. And that's an issue. And we have to remedy that. And that's through education.
It's so important for for judges to, and I think the public and victims of abuse to understand these signs of what abuse is. But it's certainly surprising to me that judges aren't all trained in this when they hear these cases. Now, Kira's Law would change that. It wants to provide for training for these judges. Jennifer, if people want to support that piece of legislation, what do they do?
Absolutely. So the first thing I would suggest is to write to your MP, in support of Kira's Law, in support of Bill C-233. If there's any questions, certainly to reach out with the MP, MP Andrew Dillon, who tabled the bill, two other supporting MPs, MP Pam Demoff, MP Yara Sachs. So we've got a petition started, any kind of interaction with your member of parliament that you're in support of Kira's Law Bill C-233 would be wonderful to help support this and ensure that this bill is enacted into law.
And do either of you have any resources you could guide someone to if they are living with domestic abuse? Jennifer.
Yes, I think there are some, depending on where the victim lives, there are certainly kind of regional hubs, in the Greater Toronto area, the Schleifer Clinic, Luke's Place. There are, certainly associations, Women's Shelters Canada, OAIT, depending on where they are. But really, the system needs improvements in terms of protecting women and children. And so while there might be protection at, for a woman at a shelter, for example, that's wonderful. The problem is then, there's going to be reliance on the family court system to protect the children.
We've got to go, but I want to thank you for coming on to share your story.
Thank you for having us.
We've heard today about the story of Kira, a 4-year-old girl who was murdered by her father, who had a long track record of domestic abuse and violence. Kira was failed by the family law system. Could better training for judges have prevented her death? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.